We're in that very small courtroom now at your request, so we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then.
All right, the breaking news banner comes out because you heard it, the judge there saying they're going to move the Karen Read trial to a smaller courtroom because of this defense request, saying that the sight lines for jurors in this courtroom that they've been using for over 100 years won't be sufficient for Karen Read. So that's what they're going to do. They're going to move it to a smaller courtroom, add some logistical issues. Part of what was a very long and very important motion hearing this morning. This is sort of the last time for all the parties to get the rules of the road straight before opening statements on Monday. With a front row seat during the hearing, Court TV Crime and Justice correspondent Matt Johnson. He's outside the courthouse now. Let's start with that, what we just heard. Looks like there's going to be a little move to a smaller courtroom. What does that mean?
Right, Ted, this was a big bombshell just outside of Boston on the eve of this trial kicking off on Monday with those opening statements. So basically, there was a lot of chatter in the gallery, everyone looking at each other when the judge, who wasn't addressing the matter before the court, that motion from the defense of the jury view and some jury members who may not be able to see the face of the witness, the defense saying that that was a violation of amendment rights of the defendant, Karen Read, 6th and 14th Amendment for her right to face-to-face confrontation during questioning. So today, the judge said that because there is not a lot of room for IT equipment, she let it slip out that they don't have the room in where this court is going to be trying the case, which is in a much smaller courtroom, which is what the Commonwealth suggested, moving to this courtroom, Ted, because of the jury question that the defense was claiming. This is a big deal because this only means that the families of John O'Keefe and Karen Read and a few members of the media will be allowed to be in there, no members of the public.
No members of the public, no members of the Free Karen Read Army. One would wonder what the defense would rather, a gallery full of people that seem to support a defendant, which we all know by sitting through trials is very important because juries, they know everyone in that courtroom by the end of a long trial. But there you go. They're going to be in the smaller courtroom. They won't have that army of supporters with them. Let's talk about the motions as well today. Several things were discussed. What stood out to you on, as you said, the eve of trial?
Yeah, we still don't have an answer on some of the major motions, whether or not her blood alcohol level will be presented to the jury. There's a decision still pending on that, and whether or not the district attorney of Norfolk County can be called as a defense witness. That's going to be decided at a later time as well. But one of the major issues and motions that was decided on today that stood out to us and our team was about the statements made by the defendant, Karen Read, outside of court, not only to the media, which will be played in part, but also to the state trooper after the grand jury indictment when she was rearrested and they added the second-degree murder charge. Well, she made a statement when she was on body camera, and that's coming in. Let's play the statement, and then let's play what the judge said about it.
So, initially, your arrest was on probable cause out of the district court, okay? So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of the death. Okay, So those are the charges the grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay?
So bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail. But typically, once murder comes into play, people are going to get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My tail light was cracked and junk was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to do your rights, okay? And I'm sure he's going to do it again. All right, if you want to talk to us, you want to give us a story, definitely. We'll take it.
No, I don't. I mean, I know you already know the story, so I don't need to.
I don't think we need the video. Much of it is just looking at their computer. So the video part will be out. You don't want it in, correct?
That's correct. We had asked for the audio only.
Yeah. Okay, so the audio only, but it needs some context. Clearly voluntary, clearly unsolicited. How do you want to work that out? Can it be that this occurred at the Milton State Police Barracks on a particular date? Because if you can't work it out, then I'll decide it.
We don't object that the statements were made at the Milton State Police Barracks as they were.
Audio only.
So the statements made to the police trooper when she knew that she could remain silent, that is going to be allowed audio only during the trial. Part of her media interviews that she gave to different outlets, that will be allowed. And then also statements overheard by John O'Keefe's niece and nephew about the relationship and possibly the deterioration of that relationship right before his death. That will be allowed admitted in as well. And they're going to be allowed to sit in the gallery after their testimony, Ted.
Both members of both families there, John O'Keefe's family and Karen Reed's family there today for this pivotal hearing, along with Matt. And now it's going to be jockeying for seats, obviously, with this news that they're going to the smaller courtroom. Matt will be there. We know that. He'll have a front row seat. Matt, thank you. As always, Matt will be with us throughout the day here on Court TV as we ramp up our coverage, getting ready for Monday's opening statements. Ooh, it's going to be quite the trial. Jack Rice, you're... let's talk about this idea that now they're in the smaller courtroom. The defense said, hey, we don't like the sight lines for jurors. Okay, well, guess what? We're going to go to a shoebox, and your peeps aren't going to be allowed to be there. What would you rather have, an army of supporters sitting behind you, or sight lines for juror 9, 10, and 11?
That's a tough call, isn't it, right? You file this under, be careful what you ask for. Because in this case, they fought a particular fight, and I don't think they really thought through what the ramifications are. I think of Johnny Depp versus Amber Heard. You think about what that jury was looking at. They were looking at them, yes, but they were looking at everything. And in this particular case, you're trying to show the broader picture of what's going on in the community right now and how the world feels somewhat outraged and up in the air about this. You want the jury to see that at every single level. And so the idea that they lost on this issue, well, I should say they won on this issue.
It might be a loss.
They lost on this issue.
I mean, look at this.
I think it's a huge deal.
Look at this shot. Look at this shot right here. So this is the view from juror number 9. Guess what? They're staring at Karen Reed supporters. I mean, perfect. It's like this is the best view ever.
Could you imagine that view of juror number 9 and 10? They're seeing him say something, and you see 3, 4, 5, 6, 8, 10 spectators be outraged and confused by what that person just said. What does that teach you? It teaches you to be outraged and confused. You're trying to get to this jury to move them. And so you always move them however you can, whether it's through scintillating cross-examination, through direct examination, through what the courtroom feels like, through tension, and sometimes, you're not supposed to, but sometimes it can happen through those spectators in the room, and they can't even help themselves.
Talk about 6 weeks. Jurors see everything. By the end of a 5-6 week trial, they know the bailiffs' names, they know everybody in that courtroom, and believe me, they'll know that, wow, this lady's got a ton of support. Holy mackerel.
For some reason, right?
Yeah.
That's what it is, Ted, right? It's like, why does she have so many supporters? Do you think it's because they like her, or do you think they might actually, and I think this is actually part of the idea, is maybe they know more than we know.
Yeah.
Maybe there's something else going on about this case, and nobody wants to convict somebody who is innocent. And if they have something out there that makes them think,
right.
that's going to give them even more pause.
Yeah,
It's
and
important.
you don't want to convict someone that you think the general public doesn't want you to for some reason, and even a cop killer. So